I like you fixing your hair.
Well, my earring gets caught in the headphones
Oh, I see.
because I normally don't do headphones, and so my earrings kind of.
Ah,
Yep,
gotcha.
it happens. It happens. But now
Hello,
we're
hello.
good. Hello,
We're
can
good.
y'all hear us?
They can, yeah, they got us.
Okay. Okay. Oh, I just pressed something. I don't know what I pressed.
Don't break anything, Alice. Don't break anything. Don't
Oh,
remember, or
everything's already
don't
broken.
forget. Don't remember. Don't forget. This is legal briefs, so you gotta
Oh,
do it.
okay. Okay. Something that something that goes with what are you drinking? Because everyone's gonna want to know.
Bourbon.
Well, a little more specific than that.
Willet. It's the good stuff.
Oh,
Yeah.
I think people would always give Judge Willett that. I think he had a
Oh,
lot of
really?
bottles of it. I mean, it
Makes sense.
makes sense. It's his
It's
name.
kind of basic, like they could be
Yeah,
a little bit more creative. But
it could be. It could be.
whatever.
Okay. Let me think. What am I gonna call you? Has to be good. It has to be good. If
It
anyone
doesn't have
wants
to
to
be that
give
good.
me,
It doesn't have to
it
be that
has to
good.
be good. Okay. You called me confusing. If anyone
Called you
wants to help me out with
confused.
the word here, Jason, there's gonna be so many outtakes because I'm still a little bit loopy. I'm not gonna lie.
They don't know that you and I talked about how loopy you were yesterday.
I'm
So
just saying I'm loopy right now.
okay.
Separate and apart from me being loopy yesterday, which I've never recovered from. So it's like double loopy.
I
Okay.
see.
Okay. I can't think of a word.
Man, when we release this video on YouTube, people are really going to enjoy this part.
Okay. Okay. I'm ready. I'm ready. I'm ready. Okay. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my willing co-host, Brett.
Hi, Alice. That was so professional the way you did that.
That was Tina, who is in our chat right now. Thank you, Tina, for saving me as my brain synapses were not connecting and I couldn't think of a word to describe you because, Brett, frankly, you are indescribable.
Like Bigfoot or, something horrible that cannot be described.
Well, you are a willing co-host because man, okay, y'all, Brett is like above and beyond everything you think he is in a positive way. He is. You guys, do you know how dedicated he's been to this trial? This man is living and breathing the Murdaugh trial, the Murdaugh trial, the Murdaugh trial. Who knows how we say
It's
it?
true. I can't get enough
For
of
your sake.
Alec. For your
You
sake.
know, actually,
Yes.
I wish we could do a poll here. What people want us to call. I almost feel like we need to set. I'm like, I'm gonna take Alec and you take Alex, or like you take Murdaugh and I take Murdoch.
I'm sticking to Alec. Alec is my
But it's
and I
spelled
like
Alex.
Murdaugh better than
It's spelled
Murdoch
Alex though.
or Murdoch or Murdoch. It's just like a slight, an
Or just
easy sort of ch at the end. It's
or
very
just like a
difficult.
murder.
Murder, that works too. Murder.
Alec murders.
Alec, alleged murder.
We might be giving away too much in this intro. Well, you guys, all jokes aside, I mean, we're so happy to be here with our wonderful patrons in this live recording. And Brett has brought the federal, what is that? The
Federal Criminal Code, Federal Criminal Code and rules.
And look how big it is. Turn it to its side, guys. This is, you thought the Bible was big. I mean, these are like rice paper thin pages. I'm not saying it's the Bible. I'm just saying this gives you a little view into the criminal justice system. And this is just the federal one. This doesn't include all of the states. Lots of rules, lots of codes, lots of elements, lots of cross references. And this is all we're gonna read through the
entire book.
We are here for your questions. We will talk about it. Just so you guys know, you're not going to get shortchanged on the trial. That will be, I don't know, a 20-part series. Mm-hmm. But tonight, we are close in time to the court making the decision to let in 404B, other acts, evidence about the financial crimes that Murdaugh is alleged to have committed. And I don't know what Brett's doing over there. I think he's doing it for show, but that is a big deal. And you've probably seen a lot of clickbait about it. Like, oh, this is either so unfair, this is correct, or what does money have to do with this? His other crimes, he will be tried for those if he chooses to go to trial. This is a murder trial, and we're here for a murder trial. What does this have to do with the money? So we are here to talk all about that and to answer your questions. And I am talking really fast. I feel like I've maybe I don't know.
Alice was up all night.
I
Not
was up
last
all
night,
night.
but the night before.
This is
That's the
true.
thing about the law. Sometimes you have to stay up all night to do your job. And she was doing it. So, but we recorded last night. She was on 0 hours of sleep. So that one's going to be fun.
That
And
one is,
then,
Jason, those outtakes are going to be amazing.
and then we're back today. And we're doing if for those of you who it's not obvious when you hear this on the podcast, this is a live recording with our patrons who've joined us for this, which is always fun. We enjoy that. It's one of the great things about Legal Briefs. We do a lot of these live recordings. And as Alice said, we are going to do a deep dive on the Murdaugh case. We've already started recording it, as a matter of fact. And who knows? We may finish our 8th episode by the time they finish the trial at this rate. You never know. Maybe, who knows? You may have heard all the episodes before they finish the trial at this rate. This has been
it's kind of a race in a way, like how fast we can record and how slow they can go.
Yeah. Well, they can go pretty slow is the answer. I know a lot of you, we talk about this some in the other episodes we're going to do, but I know a lot of you have been watching this and have commented on just how slow this has gone. And that's not what we're talking about today. We're talking about Rule 404. It's really a huge part of this case. If you've been following this, if you've watched it in real time, there was an entire mini trial about that. We're going to talk about that some too. Some people thought that was surprising or weird or unusual or problematic. And in fact, it's not. It's actually pretty common. But all of this was about whether or not these other acts evidence was going to come in this case. And I'm going to read you. I have in my hands the federal rules of evidence and the code, which Rule 404 in South Carolina is basically exactly the same. So that's why we have this fancy book here. But Rule 404A, we're going to talk about 404B here in a second. But Rule 404A, character evidence, other crimes, wrongs, or acts. Number 1, A1, prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion, the person acted in accordance with the character or character trait. And what you often see here is essentially we're not going to allow general attacks on your character to prove that you did something wrong. But it goes further than that. 404B, prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with the character. So you see, we have this general rule against using your character to convince you. This is the round up the usual suspects rule. We're not going to say, well, there's been a crime committed. Let's find all the criminals. It was probably one of them. And we'll use the fact that they're a criminal to prove they committed this crime. But it goes beyond that. You can't use prior crimes or prior bad acts to show their character to then show they acted in accordance with that character. And this is confusing to ordinary people because we do this all the time. In your life, you do this all the time. If you know someone who has lied to other people, you are less likely to believe them when they talk to you because you think they've lied before, they're likely to have lied now. But despite the fact that you do that in your life, generally speaking, we don't allow that in criminal cases.
A real life example is a lot of you, before you buy something or use someone's services, you might go to, say, Google reviews, or before you listen to our podcast, you might look at Apple reviews. And based on what other people have to say about us, you determine something about us and whether to proceed with us. We do this all the time because we live in a cohesive, complex world where our characters and our acts are not siphoned off from the rest of life. But as what Brett just read you, the law does treat those other acts as completely siphoned off from the charges that are brought before you that you are tried for at that time. And that's why, by the way, you can be charged under multiple different complaints or indictments for different acts. Because you've probably heard in this case that Murdaugh is facing, I don't know, 90, almost
Close to
100,
100.
yeah,
Yeah.
close to 100 different indictments. Why isn't it one? If they are different acts, you typically don't tie all different bad things that people do together.
And a good
So
example of this, those of you who paid close attention to the Kristen Smart case, you may recall that the prosecution in that case attempted to charge him not only with the murder of Kristen Smart, but also with some sexual assaults of other people. And at some point, the court said, we're not going to allow that. We're going to sever these cases. You got to try the murder over here, and you'll try the sexual assault over here. And the reason's pretty obvious, because very difficult for the jury to separate those two things if they're not closely related. And what you're trying to avoid here is you're trying to avoid the jury saying to itself, let's take the Kristen Smart case because it's the most sort of visceral. Alice usually, she uses this as an example. Rape is really visceral. And so you could imagine the jury's like, well, I'm absolutely convinced he's a rapist. And frankly, I don't really care if I have reasonable doubt about him committing the murder. I'm going to say he's guilty for everything because this guy never should get out. You know, I mean, it's sort of that other crime overcoming the jury's ability to consider reasonable doubt. And you don't want that. You want people to be found guilty based on the evidence of the crime itself, not on bias, really. I mean, that's the fear is you're going to bias the jury against the defendant in an unfair way. And so we want to avoid that by keeping that kind of evidence out. But
exactly. But aha, what is Murdaugh being tried for right now? Murder. Not the other murder, not the other almost 100 financial crimes. And already I'm seeing kind of like a Christmas tree pop up with lights of comments over here. But he hasn't been convicted of those financial crimes. It hasn't been proven. All good questions. And this is exactly what kind of the media has seized on. And there's a lot of misinformation there. Because what is 404B actually saying, Brett?
Well, that was 404B1. And the thing about the rules of evidence is they always sound absolute. And then there will be massive exceptions that you can drive a truck through. We've talked about this with hearsay before. You know, if you want to flip over, if you want to take your rules of evidence book that I know you all have out with you and flip over to rule 800, just a few, pages away, you'll see that hearsay also has a very broad rule. And it says, look, I can find it. The rule against hearsay. Hearsay is not admissible. Okay, that's pretty definitive. Unless any of the following provides otherwise, including these rules. So that's rule 802. And then rule 803 begins the parade of exceptions to that very strict rule that you don't allow hearsay. Same thing with 404. So 404B1 tells you you cannot use evidence of other wrongs in a trial. But what you have to do is you have to go to 404B2. And then we get into the permitted uses. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Those are a lot of examples. And
Examples.
Those are not all inclusive. Those are just some examples of what you can use Rule 404 to show. So those are a lot of exceptions. And so I think the question is, when do those exceptions come into play?
Absolutely. And here's kind of I can't think of words. Words are not coming to me right now. But obviously we've given you all the reasons why 404 evidence is not allowed in, because we don't want you to make up your mind about the character of the person based on their other acts. With these exceptions, no, it doesn't say you should, well, it's supposed to say you shouldn't use those acts if let in for one of these myriad of exceptions to go to the character of the person to then show their guilt in this instance. But we are human beings who may be instructed to act and think of things a certain way, but it is very difficult for us to completely separate motive from, say, bad acts, meaning he is more likely than not to have committed this bad act that he's being tried for.
And 404 is interesting because you think of it upon your first reading as a rule of exclusion, that it's excluding certain types of evidence from consideration. But in fact, legal scholars and courts have noted that it is not a rule of exclusion. It's a rule of inclusion. It's actually telling you when you can use evidence you wouldn't otherwise be able to use. So think about it this way. There's a phrase in the law, you may have heard it in this case, called res gestae. And what that's talking about is all of the matters, all of the events, all of the evidence surrounding the crime itself. So there's the crime itself. And obviously, all the evidence at the crime scene involving the crime, that's clearly going to be admissible. But res gestae is a little bit broader. It's sort of telling the whole story of the murder. It's why what you ate that morning for breakfast might come in, even though you didn't kill anybody until that evening. It's part of the res gestae. So there's that. All of the little things that might have happened that help tell the story, that's all going to be included. There's been some discussion about that in this case. We'll talk about how in a second. The other thing are these Rule 404 things, and they are events that are not directly related to the crime, but that you can build a bridge between the events and the crime itself. And if you can do that, if you can build a bridge and connect it using one of these reasons or another good reason, then the evidence will come in. And generally speaking, the courts are pretty broad about what they allow in if you can show one of these aspects. In this case, obviously, motive is the main thing. The prosecution doesn't have to prove motive. We all know that. But motive, as evidenced by the fact it's included in the rule, is something everyone acknowledges is important and is something that the jury often wants to hear about. And in cases where motive is particularly important, the urgency to get in motive evidence will be even higher. In this case, what do you have? This is not a random killing. This is not, at least the accusation is not, this is a random killing. If somebody's driving around shooting out of their car at random houses, what they're thinking and their motive and why they would do such a thing actually isn't that important. But when you're accusing a father of killing his son and his wife and then attempting to cover it up, then motive becomes very, very important. And the prosecution has pointed out how important motive is, and the defense in its own way has confirmed that. The defense has said things like, this was a loving family man. He loved his family. Paul was the apple of his eye. He had a perfect marriage with Maggie. They have asked witnesses things like, can you think of any reason he would do something like this? And when they do that, on the one hand, they're doing something called opening the door, which is when you as the defense say something that allows something in that wouldn't otherwise come in. But another thing they're doing is they are highlighting how important motive really is. And how do we know it's important? Because it's something they themselves are focusing on. And that really strengthens the prosecution's argument that the jury needs to know exactly what the motive might have been, what the things were that were going on around this murder that might have led to the killing.
Something Brett just said is really important for understanding the back and forth here. You apply these rules per case. There is not some perfect scientific, code or equation that lets you know when it's proper to let in 404. But Brett just said if the defense is opening the door to this type of testimony, it's fair to allow the prosecution to rebut this character evidence, this bolstering of who Murdaugh is, right? Basically, it's about fairness here. They don't get to just say, the defense doesn't just get to say, what a great, upstanding family man this person is, without the prosecution basically being able to poke holes into it. And so that's a risky thing for prosecution, because obviously that's a very powerful argument to make, and one you would think you'd want to make. It's hard for any of us, I think, to to understand what would drive someone who seems to have status and money and power to it seems to love, his family to one day snap seemingly within a matter of like an hour and brutally murder his son and his wife. And so, by them telling that story and the court acknowledging that they're opening the door and the prosecution gets to tell the full story. Remember, it's not one-sided. That's why there's advocacy. There are two sides of the V. You can't tell the whole story without the financial crimes. That's the prosecution's argument for why it should be let in, even though this is not a financial crimes trial.
And let's be clear here. There's no question the prosecution's right about this. If he killed Maggie and Paul, it was because of the financial things that were going on with him that were being uncovered on that day. There's no question about that. He did not kill them for some other reason. If he is guilty, that is why. And that makes it even more powerful that it would come in. This is not speculative in the way this kind of stuff can be. Go ahead.
I want you to press on that because a couple people have already asked this. They've said the financial crimes, it doesn't seem to come in that day. It doesn't seem to have come to head that day. So those people who haven't been following the trial closely, which you probably have lives and are not watching 12 hours of, jury trial a day. Brett, can you lay out why it is coming to a head that day?
Yes, absolutely. So the way this all happened, Murdaugh Duck had been stealing from his clients and stealing from his law firm since 2011. This was a long-going fraud, millions of dollars that he was stealing. And the first time that this came to a head was after the so-called boat case. Those of you who know nothing about this case, Paul, who was his son, who was one of the people who was murdered, was involved in a boating accident in which he was very, very, very drunk and almost certainly driving, and one of his friends was killed. And Paul and his father, most importantly, were being sued by the family for wrongful death. As part of that, and we've heard this from the plaintiff's attorney who represented the family, they had made certain demands on Murdaugh about his financials. They wanted to find his money. The problem for Alec was, despite the fact he had been stealing a lot of money and had been earning a lot of money, he'd also spent it way beyond any ability. It's a really good question about where that money went. But in any event, he doesn't apparently have the money. And this pressure is coming on him to open his books and show this. He is now going to his law firm and asking for them to structure money coming in so that it doesn't appear to be his, so it won't be the subject of this litigation. His law firm's like, yeah, we're not going to do that because that's illegal and unethical as well. At the same time, and in fact, on the very day that this happened, the law firm realized that a check in almost $800,000, I think it was like $792,000, Murdaugh had put it directly into his account rather than putting it into the firm. The way it's supposed to work is you win money, it goes into the firm, and then the money is divided amongst the partnership at the end of the year. That very day, he had been confronted by that, or about that, by one of the bookkeepers in the law firm. So, and also that day, his father, who was someone who had loaned him a lot of money and had sort of been his financial backup, goes in the hospital and is not expected to live. So you have this sort of perfect storm gathering around him on this day where everything is starting to fall apart. He doesn't have any money and he doesn't have any time. And essentially, the theory of the prosecution is Murdaugh knowing about the $700,000, but also knowing about the millions more that would come out if people continue to look into this, decided that the only thing he could do, and I actually have a different theory that once we do this, I will reveal. But for now, we'll continue the prosecution's theory. The only thing he could do was kill his family to essentially buy himself some time. And it worked. The law firm stopped looking into it. The plaintiff's attorney in the boat case said, based on that, we would have dropped him as a defendant. There was no way a man whose family has just been killed, no jury is going to give you money. So he was going to be out of that altogether. So it almost would have worked had it not been for the fact he had stolen so much money that in September, literally somebody picked up a file off his desk that they needed and a check fell out. And when they looked at the check, they realized it wasn't just a $792,000. It was a lot more money that he was putting into his own account, which led to him being fired. Which, oh, by the way, when that happened, what happened immediately afterwards? On the roadside, he was shot by an assassin. And as the prosecution pointed out, when I think he said, when Hannibal's at the gates, violence happens with Alec Murdaugh. And so, in two different instances, when he is faced with his financial ruin, what happens? One, his family gets killed, and then he gets shot by a supposed assassin. And the prosecution theory is all of this is the motive. It is what caused him to commit these acts.
Thank you, Brett. That was beautiful. That was amazing. Note, because I'm already seeing people be like, but I don't buy it. I don't buy that he's going to blow his son's brains out to buy himself some more time. We are not actually talking about whether that was his motive and whether that actually happened in his mind. What we are saying is whether that is enough to allow this type of evidence in under 404B to show motive. So those are two separate questions. Now, whether that's the best story to win for the prosecution, whether that's actually what happened, we may have some other theories and we can talk about that. But what we're trying to show here is that there is a story to be told to understand what the motive was that may have driven this man to do completely just unthinkable for 99.9% of the rest of us. And that was what the prosecution laid out. I'm not sure I would have laid it out quite like that, but you can see the argument and the prosecution is right. But that falls squarely within the rules of allowing in other acts to show motive. Whether that's a good motive is another question.
And that's 100% right. And I feel like everybody misses this when they talk about this. It doesn't matter whether you buy it. That's not the question. The question is it admissible? Should it have come in? It obviously should have. There is no question that this is admissible. I think
that's the point, right? Admissibility just says, does the jury get to hear it? Because it's the jury's job to decide and weigh the evidence to decide if they believe it. And that's where we're missing the disconnect, and we're trying to separate those two. The rules are about whether it can be even presented at all. So, I'm trying to think, like, this is a terrible example. I have had no sleep, so bear with me. But it's like I can present two different things to eat to my child, and they can choose to eat it or not. Just because I present them broccoli does not mean they will eat it at all. He makes the decision. The jury makes the decision whether to pick up on that motive. But the decision of whether to present the broccoli is what we're talking about here. And that's what 404B is. It is just a gatekeeper of admissibility. The weighing of it is up to the jury. And that's why the jury is a black box. We don't know what they'll think. A lot of you have differing ideas on whether you think that's a good motive or not. That's exactly right. But it's whether you should be allowed to hear that as the jury to consider the motive.
And two things. Number one, somebody said they understand why the June 7th stuff comes in, but they're not sure about the other stuff. The June 7th stuff, the judge said, and I think he's probably right, is res gestae. It's not even 404B. It's part of the case itself. That he learns that morning. He calls his wife and tells her, you need to come home. And then his wife and his kid are dead that night. That's not even 404B. Everything else is 404B. All the other financial stuff is 404B. And it all goes to motive. And that's why it's going to come in. Now, look, judges have a lot of discretion. I was actually kind of surprised that the judge just let it all in. I thought the judge actually would limit it more, maybe not to just the June 7th stuff, but more cabin than he has. But and maybe like I would have done the boat stuff and the June 7th stuff. I don't know about the rest of it. He's letting everything in. That's a perfectly defensible position. It will not, I guarantee you this now, if he is convicted, this will not lead to his conviction being overturned. Not going to happen. This is the judge did a great job because they did the mini trial, which is what happens. Some people asked, why didn't they handle this before the case? They filed something before the case. And the judge said, and this happens a lot in state court, the judge said, I want to see the evidence as it comes in, and then we'll decide. He takes the in-camera stuff where he actually hears from the witnesses. Then he makes a ruling. Then they have to do the witnesses all over again. And as he pointed out from the bench, yeah, it's annoying and it takes some time, but that's the law. I mean, that's how you do it. You hear the evidence and then you decide to let it in. He did a very good job hearing it presented. He heard the arguments from counsel. The arguments from the defense to keep it out were really bad. When you do 404, you also have to do 403. And 403 just says, even if it's 404B evidence that's going to come in, it has to be more probative than it is unfairly prejudicial. And there's nothing really unfair about this. I mean, it's pretty prejudicial, but it's not unfairly prejudicial, and it's really probative. So it was always going to come in, I think, under 404 and 403.
To kind of show you guys how that weighing goes, the probative versus prejudicial, I think you're right here. In this instance, letting in the financial allegations of financial crimes, or at least his financial state, is not more prejudicial than probative for the murders. But let's say it were switched. Let's say he had not been convicted of murder, but he was on trial for a financial crime, just say for the $700,000. And the prosecution wanted to bring in the fact that that $700,000 made him want to shoot and kill his family members. You can imagine that weighing of the risk, of the probative and the prejudicial analysis there would be much different. So that's a way to think about it. In that instance, it would probably be way more prejudicial than it is probative of the financial crimes. But we're in the flipped situation, which is why I think that analysis weighs in favor of it being more probative than prejudicial.
And you see that a lot when you look at the cases where the courts will say things like, you'd already been accused. Like I remember reading one in a case that I had where the guy was accused of traveling to a foreign country to have sex with 6-year-olds. And at the same time, they also tried him for some child pornography counts. And he claimed that the child pornography stuff coming in was unfair to him. And the court was like, look, there was already all this evidence coming in that you were traveling across the country to rape 6-year-olds. This wasn't that prejudicial to you compared to what you were actually charged with. And it's a similar thing. The financial stuff coming in is not that prejudicial. If it were flipped, it would be. And that's one of the things they consider.
And this might be jumping around a little, but trying to kind of keep up with y'all's very good comments here. So we've heard now that the judge is letting in everything. I really thought it was going to be a more split the baby sort of situation, but he's let in all the financial crimes. And one of you guys asked, is there ever a situation in which the prosecution wants to leave out 404 evidence? Well, the prosecution may have gotten more than it actually wants in this case. They have to make a decision of how to present all these financial crimes, because the jury is already sitting there for a very long trial. It's already been going on for weeks. It's going to go on for much longer. And they are there for a murder trial. And so far, we have seen that the defense is not stipulating to any evidence, right? They are not stipulating to custodians who are necessary to lay the foundation to admit evidence. Typically, those are like the boring people who know nothing about the case, but they keep the records for, say, Sprint, phones, or T-Mobile phone records, and they're there. They have to be there to lay the foundation to say, this is how we keep records. We produce these records and we know they're accurate because of this, and this is how you read the information. But they themselves know nothing about the case. There's a lot of that right now because they have to present the basis for the evidence, the admissibility of the evidence, and the defense will not stipulate it away. And we talk about that in our episodes, but it's a tactic to drag out the trial. With this very long trial already, and a lot of it being boring by design by the defense, whether you want to bring in every bad financial act, and we know it's at least 100, if not many, many more, and bore the jury to tears, because there is such thing as beating a dead horse when you're talking about motive. Like, we get it. Like, whether it's $3 million or $3.5 million might not make that big of a difference, but it could bore the jury to death, and they can lose sight of what you're talking about, which is the murder. So while the prosecution wanted in all the financial kind of misdeeds, the fact that they got it all, they have to be very strategic in how they choose to present it and how long it's going to take, because it can quickly snowball into a financial trial rather than a murder trial. And let me tell you, I mean, this murder trial is like as sexy as it gets. It's not like you need to, bore the jurors or anything. There is so much to talk about with the murders.
And if you want proof of that, it was either yesterday or the day before that. For the second time, the financial person for the firm testified. Somebody who's known Murdaugh since they were in high school. Her brother-in-law is heading to federal prison because of his involvement with Murdaugh and some of this stuff. She really doesn't like him. And her testimony at times was incredibly powerful, particularly at the beginning. And when she was talking about that $700,000 and confronting him that day, and how after this all happened, it all fell away and nobody cared about it anymore, and all this great stuff. And then the prosecution spends hours going through every single check that Murdaugh ever stole. And at some point, I'm like,
That was a misstep,
God,
man. That was a
it's like
misstep.
you're burying everything in this. And it's not, the jury gets it. They get it. He stole a bunch of money, and that's why you think he killed them. But by going through every single thing, you're actually weakening your point. And the jury's over there like, man, are we here for a fraud case? And we're doing a murder case, And so yeah, I think frankly, the prosecution's obsession with putting every single piece of evidence in is a mistake. And if they would have been better served if they had limited to this a little bit. They also would have been better served. Somebody is a lawyer in South Carolina. I would love to know the answer to this. Demonstratives are a wonderful thing. And I feel like if this prosecution had had a nice handy chart of every cell phone call, and they had used that to walk through, not every cell phone call, the ones that mattered, and they had used that to walk through with the witnesses or the checks that really mattered, that would have been so much more powerful than handing the person this like stack of papers and being, so turn to page 37, line 457. And this is 1430. What time is that again? 1432. That's military time. 232. And is this an outgoing or an ingoing call? Oh, this is outgoing. Okay, well, go back to line 30. It's like, oh my goodness, people, right?
By the way, that's when leading is okay. Like, get objected to, but just be like, did that call happen at 2:32? Was it outbound? And then let them object. Like there are times where you want to tell the story and move it along.
And they're not objecting to half the stuff anyway. I feel like you could lead. But anyways, I'm curious if in South Carolina demonstratives are disfavored because they're not using them and they would be so valuable. And you're just seeing that at all these places. So that is a very long way to answer the question of, yes, if you're the prosecution, you don't have to put on every single piece of evidence. One other thing I'll say, and then I'll shut up and let Alice talk. People keep saying, I don't think, I can't see killing your child over X. I hope you can't see killing your child over anything. Putting yourself in the shoes of someone and trying to decide whether or not you would commit murder if you were in that circumstance is not the way to look at it. That is not what you need to do. You need to figure out whether or not this really was happening. He really was under all this pressure. And if there's all this evidence of him killing them, that might well have been his motive. And when you combine the motive to all the evidence and you put the two together, even if you couldn't see yourself doing that, which I sincerely hope you couldn't, that is a really good argument for murder.
Absolutely. And some of you guys have made that point, but like if a bunch of you were like, yep, could see why he would blow Paul's brains out, I'd be like, whoa, like our listenership is very different than I thought. And he is, I mean, there is a reason why he's on trial here, right? Like, thank goodness we do not live in a world where anything, I don't really care how bad it is. I don't care if it's millions of dollars or, the ends of the earth that would cause you to do this to your own family. So I agree with you. This is inconceivable. And I'm glad it's inconceivable for most of you. And it certainly is for me. But it's about him. It's about what's happening in his head. And that's why the prosecution rightfully gets to rebut who the character of Alec Murdaugh is. Because if they can't do that, they can't possibly show you why this person would choose to make this decision. And it is a reasonable doubt, right? It is a plausible action for him. There was something else I was going to say, but I forget, so it doesn't matter. Oh, but you're on mute. Everybody wants to hear your voice, though.
Oh, well, I'll say this while you're thinking because I love to talk. So, a couple things on this, on what Alice was just saying. It's these kind of cases, motive's interesting. So the prosecution is putting on this evidence of motive. If you think the prosecution is dead wrong, that doesn't actually matter because you don't have to prove motive. Motive is not an element of the crime. So you can think he totally did it, but not for that reason, and absolutely find him guilty. If you're convinced beyond a reasonable doubt by all the evidence that he did it, you don't need to know why. The motive just sort of gives you more of the story. I mean, from my perspective, the motive is interesting. I think this is interesting. I think it gives a lot of color. It makes it more believable because I will be honest with you. The hardest part for me in all these cases is always that a parent would kill their children. Can't understand it. Blows my mind. Just can't even believe you would ever do it under any circumstances. I'd rather go to jail forever. I'd rather get the death penalty than have anything happen to my kids. So I can't understand it either, right? And that is sort of something that makes you wonder, like, why would you do this? But for me, the evidence itself is pretty powerful in this case. And people have asked about, do you always want to do this? There are times where you don't want to confuse the issue, because what you don't want is for the jury to go back there and say, well, man, the evidence was pretty convincing, but then they put on all that motive stuff, and man, I just don't buy the motive. And I feel like if I doubt the motive, that's reasonable doubt. And so I guess I can't convict. And that's a real danger that you have to be concerned with, particularly when your evidence is so strong. I think it is a danger worth doing here, both because I think people want a motive and because the defense has repeatedly said, why would he do this? And so you have to sort of answer that challenge if you're the prosecution and give a reason why he would do this.
All great points there, Brett. That's absolutely right. And that's why, guys, motive is an exception to the rule. If it were not if it were part of the case, if it were part of the elements, it would be in that book that Brett was just reading at the beginning. It would be in the elements. But for what he's charged for, motive is not an element that has to be proved beyond a reasonable doubt. Motive is, it's not a red herring. It's the reality that we are human beings who want to understand the world around us. You've heard us say this a million times. The best story wins. Hard to have a story without a motive, right? But that's not actually what you have to prove and what has to meet the standard of reasonable doubt. And someone just said something so perfect in the chat to show what 404B is about that I wanted to read what they said. This is what 404 A and the B and C are trying to protect against. So I won't say your name, but this was a fantastic comment. And I agree with you in life. I'm not saying that you're wrong, but this is exactly how most people think and what these rules are made for. This comment says, when I learned he could cheat his own brother and his best friend out of money and totally manipulate them, I began to realize he was all about self-preservation so he could do anything. This person, what you said, I agree with you in life. That's how I choose who I associate with in my life. That's how I choose like what store I go to based on like these types of experiences, right? Like this weekend, I had a terrible experience at a car dealership. I never wanted to go back there again. We'll never buy another car from them ever. I don't even want to step inside to, use the bathroom if my bladder was about to explode. That is me using other acts to decide what I think about them for this particular act. 404 is trying to protect against this. But I only read that comment to take us back to what we're talking about here today, which is 404B. And that B, that it mentions motive, shows you that motive is not actually central to the case and not central to the determination of guilt. So talk all you want about how financial crimes and financial woes is not a good motive. That's okay. You don't have to believe that. The prosecution is doing the best they can to try and make sense of something that is senseless, but they recognize you have to tell a whole story, right? It's really dull to just go in there. But this is why the most important evidence in this entire case, and they focused on this, and I hope this is what they hone in on in the closing argument because it's so powerful. It's not financial crimes. It's not other stuff going on. It's not about what a good person or a bad person Alec is. It's the freaking cell phone data. It's the movement on each of their 3 phones and what's happening. That video, right before their phones go dark, that is so powerful because as Brett says, this is about whether he was the one to pull the trigger and kill his family.
No, I think that's 100% right. It's 100% right. And that doesn't mean that the 404B evidence shouldn't come in, but I do think it's important that the prosecution, once they have established this, and this is where I think they may be making a mistake, establish it and then move on. Establish that he did this, and then move on and get back to the evidence of the case, and then wrap it all up at the end with the motive. Don't let it become all about the motive. To give you an example of when this wouldn't come in, just talking about the 404 stuff. Imagine, we all know he was on opioids. He had a drug dealer, just so happened to be the same guy who assassinated him or attempted to assassinate him on the side of the road. Imagine that he had gotten in an argument with his drug dealer and killed him. And that's what he was on trial for, killing his drug dealer. None of this financial stuff would come in, because the only reason the financial stuff would come in is just to show he's a crook. He's the kind of person who commits crimes, and it's not surprising he would kill his drug dealer. Unless you could tie the financial crimes to the drug dealer's death, you couldn't do that. But here, there is a tie, there is a connection that's much stronger than in that sort of circumstance. And so there is no blanket rule about this. It is case by case. It is judge by judge. It's piece of evidence by piece of evidence about whether it comes in or whether it doesn't. Alice and I, we've tried cases where we tried to get 404B evidence in, and the judge just delayed ruling, and the trial was basically over, and he asked us, "You still want to do this?" And we've said no, because we're good. We're good. We don't want to mess this up. It is an appeal issue. Now, I have no doubt he will succeed, but if he is convicted, it will be appeal issue number one in their brief that this was the wrong ruling. And I think it will stand up to scrutiny, but it is an appeal issue they're going to have to deal with. So if you are in a situation where you don't feel like you need it, better to leave it on the cutting room floor than to continue to move forward with it. Somebody asked whether or not it was unusual for the Attorney General to do this. The reason for that is the local prosecutor has recused himself, because everybody knows Alec Murdaugh, right? So he's recused himself, so you have to bring in somebody to do it. My understanding in South Carolina, it may be the case that whenever you have first-degree murder, the Attorney General gets involved. I don't know. That's a state-by-state thing. But certainly because the local prosecutor had recused, it's not surprising. A lot of times, AG's offices will step in when it's a small place. Like a big city, their DA's office handles murders all the time. No big deal. Small county where the prosecutor, in this case, is like an appointed volunteer prosecutor who's also got a civil practice on the side, who mostly handles DUIs and, petty theft, not ready to try a murder case. They will often ask the Attorney General's office to step in and handle it. So that may well be the kind of thing that would have happened here had they not had to recuse. Anyway, so not a big surprise. The death penalty is off the table. I mean, honestly, I think this should be controversial, because it is hard for me to imagine a situation in which murdering your wife and child in cold blood and premeditation shouldn't justify the death penalty. If you're going to seek the death penalty for, somebody who robs a store and shoots the owner, I don't really know why you wouldn't do that here, but that was the decision of the Attorney General. Real bold, brave decision there by the Attorney General. But nevertheless, he decided he wasn't going to pursue it. So this is a life without parole case, and there won't be the death penalty on the table in this case.
So we're here today to talk about 404B. I know you guys want to talk about the whole case, and there is a lot to talk about. But just know, we have started recording what I think will be, it might rival JonBenet in length, what this ultimately becomes, because we have no idea when the trial is going to end. And we are formulating our own theories. I don't know if we want to give it away quite yet, but there's a lot here. One thing to keep in mind, this is a slow-moving trial. The prosecution, I don't think, is near being able to rest its case. In other words, there's still a lot of evidence to come in. And remember, your evidence has to come in through witnesses. That's why you have to call the custodians to get in business records, right? One person can't get on the stand and just soliloquize and say, this is what happened, here's the story. That's the job of the attorney at the end for closing arguments. The reason is you get to cross-examine every witness and test their knowledge and the veracity and how much they actually know about what they are testifying to. And that is evidence. With all that said, the evidence is not all out yet. There's still evidence that we learn about every single day. So for those of you who are like, oh, there's no evidence of this, there's no evidence of that, we are not even halfway through the book, quote unquote. There's still so much more to go. And it is difficult when you have such a long trial. But remember, we are literally mid-sentence, so to speak. And there is much more to come.
Yeah, I get really tired of the talking heads who are like, "Well, the prosecution's losing. If the vote was taken today, he'd be not guilty." I mean, they're literally
God,
saying that on like
it's
the
not
second
done.
day of trial. Yeah, obviously, that's the reason they're putting on all their evidence. It's like, well, today we heard from the custodian of records for Verizon, and I'm just not convinced that he's guilty. It's
and
like,
and by the way, guys, there's a very good reason why jurors are not allowed to talk to anybody or read any coverage of a case. Doesn't this case and any case when you are paneled on a jury, you're not allowed to discuss the case with your family, with your co-jurors. You're not supposed to read social media. You're not supposed to seek out any outside information about the case for this very reason, because it's incomplete. You haven't heard it all yet. So you're not even allowed to discuss it with the people sitting right next to you in the courtroom to say, well, what did you think about that testimony? Did you believe him? Because you are midway through. This is like a Wheel of Fortune board with most of the board still whited out. That's kind of what's happening. And that's why the jurors cannot discuss this case even with each other until the end of the entire trial.
so somebody asked whether or not good character evidence can come in. The answer is no. No. Prohibited use for character evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. So you can't say, well, they're a good person, so clearly they didn't kill anybody. Now, the thing about the rules is they barely apply to the defense. They're supposed to apply equally to the prosecution and the defense, but the fact of the matter is the defense gets away with a lot. And there are some character exceptions to that. We're not doing the 600 series of rules tonight, but eventually we're just going to go through every rule. We're going to start at rule 1 and work our way all the way through rule like 1200 or whatever it is.
You
But
know how people do like whatever in a year, like learn all your financial disciplines in a year, and it's like a daily podcast, or like read the Bible in a year. Maybe we'll do like the criminal code in a year.
Alice, you keep comparing the criminal code to the Bible, and I just don't know.
I can't get over that you are literally flipping through the criminal code, which, guys, like, I've been hitting the head with one of those things. They're substantial. Don't ask me why I was hitting the head with one, but
Yeah. Well, tonight my daughter picked it up and told me she was going to read it. I was like,
and
good luck.
she probably could, because
Good
she's very
luck.
smart.
Well, look, we've been here for a while.
We,
What
there,
questions do you guys have before we sign off?
about 404. I'm going to have to limit it
About
because I know you have
404.
lots of questions, and you will hear our takes on the case. We promise. It's in process. It'll be on the prosecutor's podcast, whereas at Legal Briefs, we're trying to discuss the different rules, things that are happening in court in real time for you guys so that you can make sense of what's happening, because honestly, the media gets it wrong a lot.
Yeah, if Jason will hurry up and edit it, we can go ahead and release it. So y'all need to talk to him
Jason,
if you have a problem.
don't let him bully you. Okay, someone asked, are you at all concerned with the extent of the 404B financial information getting in? No, this goes back to our previous question. I think it was right, and it's completely defensible. I may not have been so broad because I would be afraid of kind of having the longest trial of all time. And then it's up to the prosecution how they want to present it. So I'm not concerned about the appeal issue. I think it's defensible that the judge let in all of that financial information. Whether it is the best interest of the prosecution to go through it painstakingly, that's just a strategy question, and I don't think it would be in their best interest to do so.
And somebody asked whether the defense opened the door by mistake. No, they knew that as proven by those of you in the chat, they knew their best defense is, how could a father do this? And their hope is that people will think the financial motive's not enough, so therefore I don't think he's guilty. They know the danger. They know what they're having to do. That's the thing about being a lawyer. You're always assessing the risk of your approach and accepting the consequences that are going to come with it, because there's always a downside to basically everything you do. And they knew that, and they went into it with eyes open.
Absolutely. All right, guys, we're going to wrap up the podcast episode, but we'll stick around if you have more hilarious comments to make. Oh, one last question. Okay, someone said the prosecution doesn't have to say this is the motive, correct? They well, when they argued for the 404, they made the argument that it was to show motive. I don't think they have to use those magic words to say it's motive, but what happens at the very end of trial is in closing, you quite literally lay out the elements of the crime. You know, we do this in our episodes all the time. There's usually like 3 or 4. It's a multi-factor elements for the crime, and you have to find each of those factors beyond a reasonable doubt. They will go through those and emphasize what has to be found and what doesn't have to be found if they're doing a good job. And in that way, you'll know what the motive is. The storytelling will tell you the motive. But you don't have to like make it explicit. I think that's the question.
You know, one other thing I want to address that we didn't spend a lot of time on. When you do 404, there's also the necessity that what you are introducing is essentially proven. You have to show by, I think it's clear and convincing evidence that this actually happened. So what you don't want to have, you don't want to have speculative evidence coming in, and you don't want to have a mini trial to prove it. If it's something that there's like a real question about whether or not it happened, that shouldn't be coming in, and you shouldn't be having a trial within a trial to prove it. In this case, it is so obvious, it is so easy to show. He's already basically admitted to some of it. Very easy. Give you a counterexample. The Michael Peterson case. The death of Elizabeth Ratliff in Germany never should have come in, because that in of itself, whether or not he killed her, was completely speculative. You basically had to have, or would have needed to have, an entirely different trial with an entirely different jury to determine whether or not he was guilty of that murder before you brought it in. And even the judge, once the conviction was vacated, was like, I never should have let that in, and I never would let it in again. This is very different. This is not speculative. It's obvious. It obviously happened. So it's much more solid that this stuff is coming in, and that is not much of a problem.
Yeah, that's a great point, Brett. So that in another way of saying that is you don't have to be convicted of that crime in order for it to be able to come in. It's a different standard. So very likely, and he's already done it for some of the financial crimes, is he's pled guilty because they are so the evidence is so heavily weighed against him. Okay, with all of that said, love all of your questions. We love that you guys are joining us on this. This is such an interesting case. I mean, this is really like the case of this year for sure. It is the case for this year, and it's fascinating. We're following it to try and give you guys the most accurate information for you to be able to understand and make up your mind as to what happened. But remember, the trial's still going. Watch it. Send us your questions. We'll do another legal briefs on it. And remember to leave us your 5-star reviews if you like what you are hearing, to subscribe to Legal Briefs and to the Prosecutors Podcast, and find us on social media. We're everywhere: Twitter, Instagram, Facebook, a lot of places. And we like to keep you guessing as to who's actually commenting on the gallery Facebook page, because that seems to be a constant topic of conversation. But before we sign off, Brett, do you have anything you'd like to add?
One free piece of advice to Alec Murdaugh and his lawyers is go find the local U.S. attorney and immediately plead guilty to all the federal crimes you can, so that eventually when you do start to serve time in prison, you can start in a federal prison and not state prison. Because while it's better to be convicted of a state crime because you might not serve any time, if you have to serve time, you want to serve it in federal prison. So he needs to take care of that as soon as possible. So that's my piece of advice to him, because I feel like this is not going well for him at this point. We'll see how it goes.
Indeed. Well, thank you guys for joining tonight and for listening. We love you guys. You keep us on our toes, and we only do these podcasts because we have the best listeners ever. So until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
I know it's not a conflict of interest to be a lawyer or a representative. People do it all the time. State reps, they have to make a living. Usually they're part-time people, so no big deal. The weirdest thing, and it's still not a conflict of interest, and I will point this out just because of all the idiocy over the Idaho case, where people who don't know anything about what they're talking about at all think there's some sort of conflict of interest in the public defender representing what's his name when
The
when she
mom.
represented the
Yeah.
mom before. That is not a conflict of interest. But what would be even crazier when you're talking about victims? One of Alec Murdaugh's lawyers represented Paul in the boat
I
case.
know.
And now Paul's the victim, and now he's representing Murdaugh. I mean, that's even more sort of like,
That's
whoa. But even
you want
that's
to talk
not a
about crazy, yeah.
conflict. But nevertheless, it's still sort of a
And
whoo
and
thing.
yes, you guys, because you guys are talking about in the chat, come to CrimeCon. We will be there. And there's a 10% off code for prosecutors.
Prosecutors, 10% off.
Prosecutors, 10% off. We'll be there. I haven't made any plans to get there, but we'll be there.
We'll be there. I kind of want to drive.
Oh, we were actually just talking about it because it's Orlando, so we might bring the kids.
Orlando. I love
you want a carpool? I mean, not like in the same car, but like caravan.
We're gonna caravan down. Sure,
a caravan with our families. That could be pretty fun.
That would be amazing.
I mean,
I would love it.
It would be kind of crazy because our kids, but but it could
you
be
can
fun.
hang at our table, Jason.
Yes,
anytime.
Jason,
bring your Christmas joy.
Wait, Jason, I thought you always do hang at our table. Of course, we need to get some. We need to be more professional. We have nothing for our table.
Yeah. We got the sign that's hanging behind me, and we
do have the sign. What? Okay, I need to get more prosecuzis. We need to get more stuff. We'll get you guys. Oh, tell us what you want, and we'll bring it to CrimeCon because everyone passes out like stickers. I feel like stickers people just throw away. I don't know.
So I like the prosecuzis.
I like the prosecuzis too, and people seem to like them too because even if you don't care about who we are, you'll get some use out of it.
Yeah.
So.
The new store is going to have koozies. I noticed.
Yahoo!
We need to design the things, but
I know. I'll get around to it. I'm sorry. Well, thank you guys.
Are we signing off?
Oh, we already signed off. We've done recording.
I don't know. I wish I had some more bourbon, but other than that, I'm in good shape.
I know. I only had my water bottle. This is not bourbon, so do what you can.
What else do we talk about? What else do we need to share with the 93 folks who are still here?
How many people were here? Because I can't see the number of people. I mean, not
100
right
and something, but it's limited exclusively to patrons this time. So people on YouTube cannot see this.
Yes, because I searched.
I'm gonna make it public here in a second, but
you guys got to be the commenters,
right.
which is awesome because we love you and we love our patrons.
There you go. That's so true.
Thanks, Leslie.
So true. She's held my hair back before.
Well, I was going to say that's why Brett has short hair because there was too much hair to hold back.
Take the bar next week.
Oh, advice: don't stress out, man. Get some sleep.
So when I took the bar, I'll tell you my bar story. So I was taking the bar, and I'd done the bar review and all that stuff, and I felt pretty good about it. Oh wow.
Oh, that's Mrs. Brett?
Like
Mrs.
coming through
for the win.
Yeah, that's just like amazing.
Are you kidding me?
I don't see
so Mr. Alice giving me any.
That's love
right here. That is
love,
man.
Right there.
You see why she's the best, and she's my best friend. Sorry, Brett.
So, anyways, as I was telling you this story, so I'm taking the bar, and back in the day, and I don't know if it's still like this or not. But at the time, there was like an essay portion, and then you had to take the multi-part. And so
multi-state part, yes.
The multi-state part, the multiple choice and all that stuff. And so, I'm sitting down, and I get the thing, and I open it up, and I look at the first question, and I have no idea. My mind just goes blank. I'm like, I do not know the answer to this question. I'm going to fail. I'm never going to be able to get a job. I'm going to be starving in the street and like all this other stuff, sort of like spiraling out of control here. And there's this big table full of water. There's like all these like water jugs and glasses and everything over here. And the person sitting next to me stands up and walks over to get themselves some water. And when they get to the table, they pass out and just slams onto the table. Water goes everywhere. Glass goes everywhere. And I look at them and I think, I'm going to be fine. I'm going to be fine.
You are cold-hearted.
And I did it, and it worked out. And sure enough, I passed. And you're going to pass too. Just don't pass out on the water table, and you'll be fine.
Gosh. You are so cold-hearted.
Look, he sucked it up. He came back in. He finished. Everybody was congratulating him at the end. I hope he passed. I don't know. But it's not that bad, and you are going to be fine. So That's the important
It's a
thing.
buzzword test. If you run out of time on the essays or you are freaking out, just start writing terms that you remember from that subject. So like contracts, trusted estates, just start writing things like rule of perpetuities for trusts in the states. I'm actually serious because they have checklists and that's how they grade. So you'll end up with points, even if they're not full points, if you don't leave it blank. Don't leave it blank. That's my advice to you.
When I did the multi-state part, so you do 100 questions and you take a break and you do 100 questions. So after the first 100 questions, I was like, I don't really know. So the second 100 questions, I decided to make a little chart of what if I was absolutely sure, if I had absolutely no idea, or if I was like, eh. And when and when I finished, it was like a perfect bell curve. 25 questions I was absolutely sure of, 25 questions I had no idea, and 50 questions I was like, eh. And it all worked out. And it's gonna
Which
work out
is
for you too.
actually the way the bar is supposed to be, right? If anyone could basically have the majority in which they knew the answer to, then it'd be really hard to make the bell curve for those who pass.
I'll
Because
tell you
the
another
bar is
story.
a curve, right? Ish. Is
The
it?
bar is on a curve.
It's
It
on
is
a
on a
curve.
curve.
That's right.
So another story. Well, I'm telling bar stories because I love telling stories, as you guys know. So I had a friend, and he took the bar in a different state, and he was clerking for a judge, and the bar results come out. His name's not on the list. So I failed the bar, and he's thinking, how am I going to go tell my judge? Because invariably, someone will tell you wherever you're working how many people have failed the bar before. And for him, no one clerking for his judge had ever failed the bar. They had all passed. And so he was going to be the first. So he's thinking, how am I going to tell my judge that I have failed the bar? And he's like working himself up to it. And he starts walking towards the door of the judge's chambers. And one of his other classmates, or not classmates, co-clerks, comes running in and grabs him and is like, don't go in there. And it turned out that a story had just come out that the bar had messed up the results. And so the results they had released were not correct, and they had to retabulate them and release them the next day. And the next day, he was on the list and he had passed. But the worst part about it, to me at least, was there were people on the first list who didn't pass. And then there were the people who realized they failed the bar the first time, heard that the bar messed up, had second hope, and then actually failed the bar. And it's like, oh my goodness. And that's a tort for, intentional infliction of emotional distress or something.
That is
But
terrible. And owl magnets, by the way, fantastic idea. I will make owl magnets. I love that idea
you need
because I will
owl
use it.
magnets and blowpokes.
That might be a little hard to travel with, but
And Team Stick. There are these people who think that like he beat her to death with a stick. And like the owl feathers were like in the stick.
on the stick,
And
like
he beat
a
her with a stick. And that's
like
where the
a.
owl feathers came from.
All
I don't
right.
know.
Well, we'll talk
I
about
mean,
that at CrimeCon. So someone what was I gonna say? No, the bar is fantastic. So I studied for the bar like in a closet. Oh, I think I have a thing for closets apparently because I couldn't focus if I was like in an open space. And you study for the bar in the summer. Summer is beautiful. Like there's sunlight, there's water to go swimming in, and so I literally had to like it wasn't even a walk-in closet. It was like had like panel doors, and I would like sit in the closet to block out all light so that I would focus and study. And it was fine. I made it. I lived. Oh, sorry, I unplugged myself. That was me. I think my
well,
recording has
Alice
stopped.
is like,
Sorry.
wait, did you, do I need to stop mine too?
I
Okay.
accidentally, while I was telling my
God,
story,
Alice.
unplugged my microphone. I know I'm the
Okay,
worst.
I'm stopping my recording.
I'm sorry,
But I'm going to
Jason.
continue to talk on here. Sorry,
Yeah,
Jason.
showing me legal briefs. Okay, let me save
Yeah,
this before I lose that too.
exactly. I'm doing the same thing.
Um,
Have I told my I'm not on mute, am I? No. Have
no,
I told my LSAT story before
no.
on the podcast?
Oh,
Jason will
please no.
appreciate this. Jason's still on, right?
Yeah, he's still on, and I'll start recording again. Sorry, I just
Oh, you are starting recording again?
I will start recording again because this is gold. This is gonna be like our entire
Okay, well,
year
hold on. Let me
3.
save this.
I'm
Let me
saving
save
too.
this.
I'm saving. Blow pokes. No.
Where are
Is it
we?
like 10
Legal
people
briefs.
left? Because should
No,
I
there's still like people are holding on, man.
how
We're at
many
92.
should I tell them my news? I don't know if I should.
Yeah, well, I mean, it will be public because when I make it public, all this will be on YouTube.
I don't care if it's public. It's just like I've waited so long.
Just go ahead and
I'm
do it.
quitting. I'm quitting. I'm quitting the
I mean,
podcast. I'm just kidding. Just kidding.
You've made it this far. You might as well
I
tell
know.
them that
One
you're
second.
leaving the
Let me save
podcast,
this.
and
Hold on. Hold on. Okay. Are you ready to
we're taking
record?
auditions for the new Alice. So
Okay. Are you
I
recording?
hope some of
Are we
y'all are ready.
recording?
No, I'm not recording yet. I'm
Oh,
still
okay.
saving.
Okay.
Hold
I'm
on.
sorry.
Oh my
Jason, do you
goodness.
see what we go through for you? That we like care so much because Alice gets a little sidetracked.
All right, so I'm supposed to start a new recording. Is that what I'm supposed to do?
Yes, because we just saved another one. Okay. Are you ready?
Okay, I am starting. Okay, I'm ready.
Wait, recording in 3, 2, 1, record.
Okay,
Is that
I'm
working?
recording again.
Yep,
Yes.
I'm recording again. Okay, I'll
It's
label
been
that.
fun, Alice. I mean, this has been a great experience. I've really enjoyed doing this with you. Hopefully, people will stick around when it's just me. But
Oh gosh. Okay. No, I'm not leaving. I'm not leaving. I'm sorry. We joked about that much too long. I'm not leaving. I mean, I'm not dead yet. Stay here. No, my news is I'm sorry. I think the chat's like a little delayed and it's really funny. I'm just curious, how many people are here? Like, how many people am I telling?
88.
I mean, I'm telling the world.
89.
80. So can I tell you a real story about what I was afraid of tonight? And this will lead to that. So I legitimately thought there was a non-zero chance that I would go into labor during this recording tonight. And it's because I'm having a baby.
Well, I'm glad you didn't.
It was like a non-zero chance. I was like, I'm feeling a little weird tonight. Like, this might be one of those, like, hey, bro, we're gonna have to wrap it up because I have to go to the hospital.
I mean, Alice famously, the last baby she had was in the middle of trial, and she finishes up all her witnesses, and then is like, "Okay, guys, that was my last witness. I'm currently in labor. I'm going to the hospital."
And I did. I felt labor, the onset of labor at about 11 a.m. And I went to the hospital after trial, finished the day. It was a great day of trial. We won. And when I showed up at the hospital, I was 7.5 centimeters dilated. For those of you who don't know, you start pushing at 10. So like 7.5 is active labor, and like you definitely shouldn't be walking around. But it worked out just fine. It worked out just fine. And that baby is not a baby anymore. He's a toddler, and he is like so chill. I don't know how. I think he had so much surge of cortisol that like he was just like, I don't even understand what,
Tell them what
is.
you're having.
Oh, Alice is taking maternity leave. Brett doesn't give maternity leave on the podcast, please.
Yeah.
Okay, let me put you all at ease though. I am having a baby. So give us some grace if, for my loopiness. That's part of the loopiness. I haven't slept in a very long time. And I won't be sleeping, I suppose, once the baby comes. We have recorded like crazy so that there's no gap. And you don't want to see this belly because, like, I know it's so big because today every single person I saw in public was like, oh my gosh, should you be in a hospital? And I was like, no, just trying to get my groceries. Thank you so much for commenting. So we've been recording like crazy. We don't anticipate a gap in either legal briefs or prosecutors podcast, but we'll see how it goes. And yeah, thank you guys. But you know what's kind of I kind of forgot to tell a lot of people.
Tell them
So
what you're having.
Oh, I'm having a girl. I have 2 boys. This is finally having a girl. We're very excited. I think my kids are super excited about a girl. Like, I didn't expect this. They're so happy. They actually have been wearing bows in their hair. Like, it's very cute. They put it on their stuffed animals. So they get it. There's a lot of belly here, trust me. But
And
yeah,
shout out to everybody we saw in Florida for not like leaking that news.
Yeah, they
Alice
were
showed
like
up very pregnant to the
"Whoa."
bar.
So pregnant. And people were judging. They were like, wow, that kind of mother are you? And I was like, that's right. Fully baked child. Don't you worry.
When she started throwing back Jaeger shots, they were like, wow, okay.
Just trying to make a chill baby over here.
There you go.
My point was, I think I have forgotten to tell a lot of people in my life who don't see me on a regular basis that I'm having a baby. So a lot of people might be finding out, like, in my life when this goes public.
And by the way, the name is Brittany. So we're all looking forward to young little Brittany coming into the world.
That's a disgusting. I'm sorry if that's any of y'all's name, but it's really not good. Anyway, sorry. It's completely I completely detracted us from bar
You interrupted
advice.
my LSAT story.
Okay, will
Nobody
you
wants to
tell
hear
us
my
your
LSAT
LSAT
story
story? Tell
anymore
us your
now.
LSAT story.
I mean, goodness gracious.
Tell us your LSAT story.
Well,
We
I
should
don't
know.
know. I feel like we should talk about babies now. I
We should
feel like
not
we've
talk about
moved
babies.
on.
Tell me about
Okay,
your
I'm gonna tell my
thing.
LSAT story, and people ask questions about babies, then she did. Okay, so the LSAT. As some of you may know, I enjoy a couple things, and enjoyed a couple things in college: football and drinking. These were two things I liked a lot. I also went to class, but drinking and football, those were good things. And I was not in a fraternity, but I had like a sorority that I hung out with all the time. So I always got to go to their parties. And I decided the LSAT was coming up, got to take the LSAT. And it's always in the fall. And so I looked at the LSAT date and I realized the LSAT was on the same day as the Alabama Georgia game. And I had tickets to the Alabama Georgia game.
Oh my gosh.
And I wanted to go. And so it's like, well, man, how am I going to take the LSAT and go to the game? And the answer was obvious. I'll just take it in Athens. So I sign up to take the LSAT in Georgia with the intention of going to take the LSAT on Georgia's campus and then going to the football game immediately afterwards. So the Thursday before was like the crush party, which is like, somebody from the sorority who has a crush on you grabs you and takes you to the party or whatever. You get these cool orange shirts or whatever. They're great. Anyways, and I went and I was really into Long Island iced teas at the time. And I just might have had too many Long Island iced teas. And so I drank way too much. That was on Thursday. The LSAT's going to be on Saturday. But I'm thinking I got plenty of time to recover. But man, I really went hard. So then Friday comes. I'm very hungover. We got to drive to Georgia. We get going late. So myself and my wife, who at the time was my girlfriend, we head to Georgia. We get there like after midnight, right? And
Wait,
it's like
you get there Saturday, like going into Saturday?
going
Like
into Saturday after
you're
midnight.
gonna take the test in like 8 hours.
I'm going to take the test in like 8 hours. And my plan had been to get there, find where the test was and everything else. But it's after midnight. I'm exhausted. So I go to sleep, right? And I get up the next morning and I get lost on the way. And by the way, so I'm all dressed up in my Alabama stuff. I've got my like houndstooth hat on. I'm
In
like,
the
I'm ready to
wrong
go.
city.
And so I get lost. So I finally get to where the LSAT is. And I'm like rushing into the LSAT. And I'm literally the last person to show up. I sign in. They're like, hurry up and go inside. I walk inside to this huge room, massive room, right? And every single person in the room, all dressed head to toe in Georgia gear, because they're all Georgia students, turn and look at me. And I have never felt more out of place in my life than there in my like Alabama stuff from head to toe in this place where I'm gonna take the LSAT. So I'm completely discombobulated. Everybody's looking like they want to kill me. I sit down and I think to myself, as long as the first section isn't logic games, I'll be okay. And we get the stupid test, and the first section is logic games. And I'm like, oh, God. So, long story short, now that I've told the whole story, I finished the test, and there's like at the end, there's a little box, and it's like, if you would like to just vacate this test and do it again, sign here. And I took my pen and I signed that, turned the thing in, and went to the football game.
You vacated the score?
I did, because I was like, I have failed this. Like, this is going to be terrible. And then I had to take it 3 months later. And obviously,
Oh
okay.
my goodness. Oh my. Okay. That's insane. And by the way, guys, all I have to say is everything you need to know about Harvard Law is in that story. Oh, yes, I did.
Whatever.
Oh my gosh, that's incredible.
Yeah. I did not put that in my application. There was a section. So the thing about it is, it's not usually a good idea to vacate your LSAT. So I did have to write like why. And basically I was like,
I'm
I did
drunk.
not feel well that morning, which was true. I was like, I did not feel that well this morning.
I made repeated bad life choices, one after another.
And I will say this, after that, I stopped drinking. Like, I was like, I'm not drinking until the LSAT's over. And I was totally dedicated. And I went to the LSAT in Tuscaloosa in December and took the stupid test. And then
and got to Harvard. Guys, I'm telling you, all you need to know about Harvard right here. Well, that was like the best story to end on, really. I can't believe all you guys are still here, but that was the best story. I don't think I ever knew that story. That's incredible. You are a wonder. You are a wonder in so many senses of the word.
Yeah. Well, I do what I can.
Oh my gosh. This is great.
Yeah.
Okay.
Well,
Well,
this has been awesome.
this has been amazing. We love you guys. We will do maybe more of these. I don't know. We'll see
This
the
may be the last
situation.
one.
No. They're like, we're kicking them off live stream. No, but this has been fun. We love you guys. This has been really fun hanging out with my 89 best friends.
Best
Or how
friends.
best friends and dads. Okay, you guys, this is the best. Brett, I missed you today. You have an early morning.
I do have an early morning,
All
so
right. Well,
I'll deal with
you
that.
get some rest, and you tell Mrs. Brett hi, and she was the star of the show tonight.
Star of the show. Okay, guys. Love
Bye.
y'all. Bye, Alice.
Bye.
Bye.